Our first speaker tonight, I'm excited about introducing, it's Candice Jackson. She's going to encourage us with the law and share her insight on litigation. She's going to explain how the law does protect fair competition and equal representation for female athletes. We just have to be willing to hold people accountable. I'll share a quick story before we let her talk. So just a few weeks ago, several sports advocates were on a phone call, and it was shared that at a high-level meeting amongst governing bodies that the reason these rules are in place to include male athletes in women's sports is because the sports organizations are afraid of getting sued by the males who want to participate. But, quote, the women won't sue. The truth is, most of us didn't realize in this day and age that we would need to. We expected that governing bodies recognized us as valuable. We'd already fought this battle, and they recognized that we're deserving of fair treatment. We also expected that the law would protect us. It appears that we need to find our voices again and make sure we aren't relegated to the sidelines or that our sports aren't discounted to participation categories without rules in place to protect their integrity. Tonight, we have Candice to talk to us about these legal issues and how governing bodies in sport and legislature are exposing themselves to cases of discrimination against women and girls. So Candice is a partner with the law firm Jackson Bone, launched in 2022 to fight for the sex-based rights of women and girls. Candice served as the head of the Office for Civil Rights and Deputy General Counsel in the U.S. Department of Education from 2017 to 2021, where she spearheaded the nation's first Title IX regulations addressing campus sexual harassment and assault. So thank you, Candice. Please take it away.
Thank you so much for having me here tonight. I thought I would start with some perspectives that I gained throughout my 4 years serving in the education department and working so much on Title IX laws and regulations and policies. Title IX was definitely at the center of controversy and attention throughout the Trump administration, but not really in the context of women's sports, at least not until about the last year of the administration. The first several years, we were focusing on the first binding legal regulations spelling out how schools and colleges and universities need to handle and respond to and prevent sexual assault and harassment on campuses. So we were grappling with tough questions like, where's the line between a student or teacher's freedom of speech and offensive statements that can be punished as harassment? Or when somebody's accused of sexual harassment or assault, what kind of procedures ensure a fair and accurate decision and determination about guilt or innocence? How can we improve reporting of sexual harassment and assault and require schools to reach out and offer supportive measures to anybody who's been reported as being a victim so that Larry Nassar type situations don't recur? So those were the kind of things that we were dealing with. But as we worked through developing those kinds of rules, we were working off a fundamental premise that seemed obvious and unassailable, right? We all know who men are and who women are, and that there are differences between men and women. I mean, after all, the only reason that we had data showing the extent to which women, for instance, are disproportionately victimized by sexual assault in schools and colleges is that data collected over time is disaggregated first and foremost by sex, not by personal identity, not by spiritual belief, by sex. So we worked out those regulations, and then the Supreme Court threw an unexpected wrench into the Title IX legal landscape in a decision that wasn't about Title IX, but was about a law that uses similar language to Title IX in the context of workplaces. Title VII of the 1964 Civil Rights Act says that there can't be discrimination because of sex in the workplace. So in June of 2020, just a few weeks after our new Title IX regulations had been finalized and released, the Supreme Court decided the Bostock case. And so for anyone not familiar with the case, the basic takeaway is that our Supreme Court ruled that that employment federal civil rights law prohibiting sex discrimination also applies to discrimination because of an employee's homosexual status or transgender status. Didn't define those terms, by the way. No doubt that the Bostock case did women no favors by expanding sex discrimination law into the territory of things that at most can be considered sex-related characteristics or things, sexual orientation, whatever gender identity is, nobody defines it, including the Supreme Court. The Supreme Court's rationale, in my view, was facile at best. Justice Gorsuch took the lead and wrote the opinion, reasoning that, well, an employer can't base a hiring or firing decision on an employee's homosexuality or transgender status without first taking into account the employee's sex. You have to know their sex in order to know their sexual orientation. You have to know their sex in order to know that they're claiming a transgender status. So based on that simplistic reasoning, 50 years plus of employment anti-discrimination laws existing to protect women, all of a sudden we're thrown into the realm of apparently existing all this time to also protect men who want to be treated as women at work. If the Bostock decision was truly confined to hiring and firing decisions based solely on an employee's status, women's rights might have been unaffected, but the Supreme Court didn't bother to specify that discrimination in hiring and firing is very different than just simple things like factually recording an employee's sex for data purposes or providing sex-separated facilities or services as an employer. They didn't address that at all. So immediately the gender identity activists began using the Bostock case to argue that it's illegal discrimination to ever acknowledge sex or to ever provide spaces or services separately to the two sexes. And right away, activists were beginning to be pretty successful persuading federal judges that Bostock needs to apply not just to employment, but also in the education realm under Title IX. Title IX, of course, for all of its 50-year history, has expressly allowed schools to provide certain things separated based on sex. Intimate facilities like bathrooms and locker rooms are specifically in the original 1970s Title IX regulations. Providing single-sex housing and dormitories it's been in there all this time. You can do that as a school or university. Athletics has been in there all this time, that schools can provide sex-separated athletic categories based on sex, and in fact may need to do so if that's what's required to end up providing equal opportunities to each sex. So by late summer 2020, inside the education department, we were playing catch up. We were realizing that very, very quickly we were losing legal momentum for protecting equal athletic opportunities for girls and women because of the way that the Bostock decision was being thrown around and expanded right away. We took as much action as we could in those last few months, but everything done was reversed and undone on day one of the Biden administration through new executive orders and rescissions of enforcement actions where we had declared schools to be in violation of girls' rights under Title IX by having essentially mixed sex teams, all just kind of swept aside and reversed almost from day one. So that's where we stand now with the education department claiming that Title IX now means that all educational institutions need to replace sex with gender identity. That is obviously setting a tone outside the educational environment, and if nothing else, greasing the wheels for the continuation of sports governing bodies to continue on the path they had been on since 2015-ish of issuing policy after policy in the direction of so-called inclusion. States, of course, in 2021, 2022, really started fighting back. Many started passing state laws trying to protect women's sports. Nearly all of those laws are tangled up in active litigation. And that's how we ended up with Americans watching on in, some degree of shock as, male swimmer Leah Thomas dominated what used to be women's competitions. So over the last 2 years, and as part of launching a law firm dedicated to restoring and advancing sex-based rights for girls and women, I've tried to think a lot about how we got here and how where we go from here. It is astounding that the momentum seems to so quickly have gathered up on the side of those who deny the reality of sex, deny that male and female are fixed or objective categories, deny that girls and women deserve our own sports and our own intimate spaces and services for basic fairness, for physical safety, for dignity, for privacy. And it's got to be tempting sometimes, right? To step back and look at the state of things and think, is it game over for women's sports in the US or across the world even? Did we have our day in the sun for a few decades and now we just resign ourselves and our daughters and granddaughters to sliding back into the competitive shadows? No. That's the short answer. No way. We haven't even started to fight back against this yet. Legal challenges have so far been few and far between, not only in the US, but worldwide. There are lots of reasons for that, especially in sports. It feels tremendously unjust to put any kind of burden on girls and young women who are just trying to establish themselves and their careers and their futures, to ask them to step into what has astoundingly become a controversy like this. So there are lots of reasons why legal challenges have been a little slow off the ground. But here's where we're starting at. It's going to sound a little daunting, but I promise I'm going to leave you with optimism on how we're carving a path forward to getting women's rights back on track. Sports governing bodies have historically had a lot of autonomy, and holding them accountable for any manner of unfairnesses or inequities has always been an uphill task. It seems like it's happened overnight, even though it's really maybe been over the last handful of years that federal courts have seemed to buy into the gender activist claims that sex differentiation is somehow negative and punitive toward anyone who doesn't like the sex category they objectively fit into. Gender identity activists spent a decade or more infiltrating gay and lesbian rights organizations and women's rights organizations and thoroughly captured them ideologically from the inside, essentially leaving all of our, long-standing, our legacy organizations that stand for civil rights or minority rights, kind of like zombies, where the shell is there, but they aren't alive anymore. They recite their original mission and purpose, but they're actually taking actions contrary to their original purpose. For instance, advancing equality for women. Sex slipped into gender, and so the terminology around that has provided a buffer of obfuscation and confusion that has benefited those who want to tear down categories and make defining anything some sort of evil of exclusion, as opposed to the rational basis for ensuring and measuring equal opportunities among disparate groups of people. It's very similar and analogous, by the way, to the way that gay or lesbian has slid into just being labeled queer. It all results in very meaningless categories that have no objectivity and elevate inclusion as some kind of primary value at the cost of all other values that we've always proceeded based on, like fairness and equal opportunities. So that's where we're starting from, but here's where we're going. While we shouldn't have to prove that women deserve equal opportunities to compete and succeed and benefit from sports, or that for that to occur, women actually need female only categories and spaces and activities, we do have to prove that. And thankfully, there are incredibly bold and rational scientists and people in the sports field who have stepped up and are patiently explaining to the world that yes, men and women are different, and male competitive advantage is a thing, and men don't become women by changing T levels or even surgically altering body parts. When a travesty of justice like the Leah Thomas season can happen without having spontaneously resulted in immediate reversion of policies back to absolute protection of the female category across all sports, it's clear that we're going to need to fight this battle for women's rights in court, as well as continuing to fight it in boardrooms and in the press and political venues. But these legal battles haven't begun in earnest yet. There are some groundbreaking lawsuits out there, like in Connecticut, challenging sports association policies that decimated women's categories, and in Idaho, defending the state law that aims to preserve female categories. What we need now is coordinated tactical actions against sport-specific governing bodies, whether we start with swimming, rowing, track and field, or something else. And the NCAA needs to be hauled into court to answer for how its policies are forcing colleges and universities to violate the rights of female athletes. Even though a lot of those member institutions are wholly on board with doing that, it still can be said that NCAA is essentially compelling that result. The gender activist crowd relies on our sense of fairness, but turns it against us, and uses the concept of discrimination in a way that really has never been understood or applied before in all of civil rights history. And that is switching from the difference of when we're talking about discrimination that should be illegal, that should be prohibited, that is negative and should be not allowed. We used to be talking about taking punitive action against somebody because of their characteristic, often an immutable characteristic. What the gender crowd has turned the concept of discrimination into now is that not catering to each person's individual feelings or beliefs constitutes discrimination that should be outlawed. It's a very different and upside down view of what discrimination prohibited by law has always meant and should continue to mean. So we need to force the legal system to confront the inherent illogic of that premise, as well as the intrinsic, very direct and palpable harms that fall onto women from such a position. So we need to ask questions that get answered through court actions. Is the NCAA conspiring to deprive girls and women of their civil rights by forcing its member institutions to deny equal opportunities? Let's find out. Has USA Swimming already violated the rights of its female membership and subjected some young women to sexual abuse by rules that permit men to invade women's spaces? Let's find out. Is US Safe Sport dropping the ball on its statutory purpose of improving the safety of women in sports? Let's find out. These are the kinds of legal actions and claims that need to be strategically advanced at this point. We need to open up the courtroom doors for a wide variety of affected women and girls. There are going to be some brave young women, excuse me, who might choose to sue on their own behalf. There might be some charitable organizations with missions specifically to advance rights of girls and women who may jump in and sue on those girls' behalf. So the other category is parents. We're looking at groups of parents who have daughters at the earlier stages of recreational and competitive sports who want to jump in and argue that the risk that institutions and sports associations are placing their daughters at is an unacceptable risk. So those kinds of class actions are currently under evaluation. The important thing to remember is that all of the legal protections that women have had to fight for over the last 200 years are still in place. We have a lot of laws that already say you can't treat women as less valuable than men. You can't give resources and opportunities to men that get denied to women. We have a lot of laws that already say sexual predators and organizations that cover up for them can be held legally accountable for causing those harms. So sporting bodies and educational institutions that jump on board and latch on to a newfangled reinterpretation of those laws and somehow flip them upside down as though they mean the opposite of what they actually mean, as though they now mean that women only get our own activities and spaces and services as long as men choose not to try to take them over and dominate them. Institutions and associations that rush to jump into those brand new interpretations of very long-standing legal interpretations and precedents do so at their peril legally, because the historical trajectory of equality of opportunity and equitable distribution of resources has always been, and despite this bump in the road, will continue to be based on material realities, not on subjective feelings. We have not lost the legal right to sex-based protections. It is just temporarily being hidden behind a cloud of phony academic confusion and mystical fads of belief that humans can somehow wish away reality. But reality will prevail, truth will out, fairness will win. And any organization or institution that thinks that women are not going to get loud and litigious over the loss of women's sports is making a grave tactical error. So all of these legal avenues are in active discussion and planning. It is going to require the commitment and dedication of a lot of lawyers, a lot of girls and women of the younger generation, and that's a lot to ask of them, of a lot of women of our more senior generations, and the focused attention and financial resources of organizations who do still know who women are. But we are going to prevail, partly because the notion that a personal feeling or identity creates or changes material reality is too fantastical to remain in vogue forever, partly because American law and justice has a long and deep history of commitment to rationality and fairness. And partly because women are not going to give up. We're not going to shut up, and we're not going to take a back seat. So that is that is the legal landscape in a nutshell that I wanted to share with you all tonight. And I am curious to see if there are questions or follow-ups on that.
Candice, that was excellent. I see do you see the chat where someone was asking for a clarification on the Biden executive order? Do you have any information on that?
Clarification on okay. Well, the thumbs up updates on that is that the executive orders and the written policy documents that flowed from those initial executive orders were challenged in court by a group of 20 state attorney generals banded together and filed a lawsuit against those executive orders and those policies reinterpreting Title IX and Title VII on the employment side. And just we're already in November. Okay, I was going to say last month, just 2 months ago, the federal court in where that lawsuit is pending in Tennessee issued a decision that halts enforcement by the Biden administration of those executive orders and those policies. That is a huge win, because that federal district court in Tennessee looked carefully at the Bostock decision and completely dragged the education department over the coals for overstepping and overreaching what that Bostock decision does or doesn't have to say about sex separation under Title IX. So it was a victory.
Now that was for the day one rewrite, right? That's separate from the Title IX executive order, correct? But I heard maybe you can clarify that those are going to link together in that court case. So can you help us with that?
Yeah, that court case is only about the initial day one executive orders and policy documents about 6 months after that said, here's our new interpretation of Title IX. Title IX really applies to gender identity. Sex is kind of still there, but really it's all about gender identity. Maybe in part knowing that they were in some legal risk for making that huge of a reinterpretation of a sex discrimination law just through written policy. The Biden administration this year released proposed regulations. Now, if they pass their regulations, they would be aiming to at least have gone through the appropriate procedure, put it out, notice to the public, receive public comments, then make your regulations final. They are in the process of doing that. But the thing is that Tennessee lawsuit where the judge said Bostock doesn't apply like you think it does, you can't do this. There's a lot of good reason to think that even if the Biden administration goes forward and finalizes its proposed regulations under Title IX and would be trying to formally write into the regulations that Title IX covers gender identity now, and that schools have to allow participation based on gender identity. There's a lot of good reason to think that that could be challenged as something that, at the end of the day, only Congress could do that. The education department on its own, it's kind of overstepping for the agency to choose to reinterpret the Title IX statute like that.
So those two cases have to be, or will stay separate. You like the case
they are separate, because one is a lawsuit that the one in Tennessee is a lawsuit that now says, Biden administration, you can't enforce your policies that you just wrote. And it'll have to be a new legal action that challenges any kind of regulation that the Biden administration comes out with under Title IX.
Yes. How is the best way to go after the disc golf organization and the cycling organization that has recent male winners?
Yes. So the formula is going to have to include looking at whether there are individual women who suffered harm, who are willing to come forward and say, well, now I've been injured, now I've been damaged, now I've been harmed. You need to compensate me, and you need to change your policy going forward so it doesn't happen to other people. So that's the first line of inquiry for all of these types of situations, is looking at whether there are people who were directly harmed, not just standing by and not liking what we're seeing, but people who were directly harmed and lost something because of the eligibility policy, who are willing to step up and stew over it.
Okay, and then I see one here. How does one navigate a state sports federation like California or CIF that speaks, where you have a situation where if you speak out against men in women's sport, they immediately say you're bullying, this is transphobic, and a student or a parent can be punished by the school or face repercussions in the school. How do you handle a situation like that?
Okay, that situation too, I think gives rise to a number of legal claims. And so if the answer to the question, are you willing and do you want to do something legally about it, is yes, then there are multiple avenues of things that can be done. I think that even though it feels futile right now, I think that we need to hammer the Office for Civil Rights in the Education Department with administrative complaint after complaint after complaint for all of these situations that come up. At least force them to have to grapple with it, to have to deal with it. They're not going to want to, and they're not going to want to come to the correct conclusion about it, but it's good to go ahead and file the complaint.
So how do you file those complaints? Do organizations have to do that, or can individuals do it?
Nope. Anybody. Well, then, and the nice thing about administrative complaints with the Office for Civil Rights like that is truly anybody can file it. It doesn't have to be the person who was injured. It can be a concerned organization. It can be an advocacy group. It can be anybody. So filing those administrative complaints is great. The other thing to look seriously at is that, yes, schools are trying to frame these punishments and these retributions as, well, you're engaging in bullying and you're engaging in harassment based on gender identity or whatever. But in reality, and this is starting to prevail and win in court after court, that is a straight up speech violation. That is a straight up First Amendment violation. The Biden administration's Title IX regulations that they proposed would absolutely set this up to happen on a regular basis, where just voicing, expressing, speaking, writing in favor of female only sports or other activities can get you accused yourself of being a sex-based harasser under Title IX. That needs to get challenged in private litigation in court. Schools that are doing that and taking that view with or without the federal government's urging or even requirement need to be sued, because federal courts are starting to pay attention to the importance of recognizing that stating things and expressing viewpoints, even in the touchy realm of who are men and who are women, is something that just goes straight to the heart of First Amendment protections.
Okay, so 2 questions from that. So would an individual who, would that need to be taken, like an individual would need to be public the way, say, the Vermont parents are publicly suing to take up the First Amendment thing? They would have to be willing to be public, right?
Yeah. It's very, now the name of a minor child can often be kept out of the public court record.
Okay.
So there's that level of protection, but generally speaking, yeah, in any kind of litigation is usually open public record.
Okay, and then the question on the complaints you were suggesting, can you please tell us what those are called again?
So those are administrative complaints filed with the Office for Civil Rights. It can all be done online these days. And you just say, I believe that my school or this school that I'm looking at violated Title IX, and just fill in their complaint form, and that gets it started.
So do you would say violated Title IX? Can you also talk about freedom of speech, or no? Would you stick with
no? The education, the Education Department doesn't have a purview over freedom of speech. Just the issue of Title IX, so sex discrimination.
Got it. Yeah. And I want to give an earlier question that came up. Your reflection on how we got here is so helpful. You mentioned brave scientists, and I'm very curious about the contribution from psychologists, clinical psychologists, social psychologists, developmental psychologists on this topic. It feels to me that this is a missing lens, and it would focus on the intentions of the trans person while defending women's rights.
I think I see exactly what's being said, and I agree very much. I think we're seeing this in my new law firm has a case pending in California. It's been ongoing for over a year to get men out of women's sports. And that is a situation where if we can make it past the initial hurdle of the state wanting to just dismiss the whole lawsuit, I do see room for psychological experts to come in and talk about the impact on women and the impact on the trans identifying person, and try to help a court and a judge sort through that. So yeah, I do see a role for the psychology profession to get more and more active in all of this sex-based litigation. It's a good point.
Great. Candice, are there any other, Marcia, did you see any other questions in here that I missed?
Just one more for you, Kim.
Okay.
How are we going to fund these lawsuits?
We are going to raise money. So we're present, just so you know, as far as Icons goes, we're looking to be a resource for people to be able to move forward with these lawsuits. And we are looking forward to working with Candice and other lawyers to start holding governing sports and different bodies accountable. So fundraising, we're waiting still for the federal government to give us our 501c3 official documentation. But in the meantime, we are we have our status, we have our EIN number, but we're waiting for the official before we go full bore online and starting to raise money much more publicly. We are raising right now though, so please do contribute if you're interested, because as soon as we have the funds, we can get going.
I'll just can I add,
please,
for situations where there are individual claims going on, maybe related, like the free speech claims, for instance, if there is a strong basis for a private Title IX lawsuit saying you discriminated against me based on my sex, hey, you also violated my First Amendment rights, those kinds of individual actions, often you can find a lawyer to take them on contingency. Might be a little harder right now these days on this issue, but that's part of why lawyers like Lauren and I jumped into, to dedicate a firm to do this, because there's no reason why those kinds of suits can't operate on a straight up percentage share. Contingency arrangement is what it's called. So people don't have to come up with their own set of six figures just to sue their school when they've been unfairly deprived of their constitutional rights or Title IX rights.
Sure.
Wonderful.
Fabulous. Thank you, Candice. This has been great.